Hi, Darren Mangum here, securities lawyer with the law firm Mangum and Associates. Thanks for jumping on my YouTube channel. I appreciate you watching, sharing, liking, subscribing, all of the above. Today, I wanted to talk about stable coins and the Genius Act. Um, as most of you probably know, we do quite a number of cryptocurrency or tokenized asset type offerings, often through safe agreements or SAFT agreements, investment contracts for the issuance of tokens, digitized securities, things of that nature. And you know, we get even though the Genius Act was passed last year, I still get it from time to time. Hey, we don't think we're selling these tokens. We're not considered securities. Um, and because of the Genius Act, right? And the Genius Act obviously really is very, honestly, it's very limited to only stable coins, right? So there's lots of different types of digital assets, digitized tokens. Um, Honestly, the Genius Act really just applies to stable coin issuers that are issuing tokens that are tied one to one for liquid, low risk assets, and they're obviously um, in addition, they need to be a permitted issuer. They've got to be a regulated entity like a credit union, like a bank, like those sorts of type businesses. Now, you could have a startup and associate with one and just be kind of the technology provider arm or segment, like do a joint venture or some kind of joint venture with, but you have to have that regulated bank and those stable coins that you're issuing need to definitely be backed one to one with liquid low risk assets, right? And I'll give you a couple examples. So I've got one client who they're issuing tokens that um, very similar to another high profile company out there that they're just saying we're issuing tokens that are tied to Bitcoin specifically, right? So that's kind of a derivative of Bitcoin. Instead of buying Bitcoin directly, you're buying it. You're buying this other asset, and that's all their strategy is. It's very, I mean, from a business model standpoint, it's very simple, but and for whatever reason, I mean, sometimes investment funds they can't or pension funds they can't hold those assets directly. They can't hold Bitcoin directly, but they could buy another issuer who then like through a derivative and own those assets. Um, Obviously this client, they said, hey, we don't think we're securities, because that's that's what the Genius Act says. Hey, if you're issuing these kind of stable coins, um then it's not considered a security. It's more under the banking rules, right? It's not a but we had to unfortunately tell them that yeah, they were in fact still governed by securities laws, and that unless they could certainly partner with another um, a bank or a credit union, some other regulated financial institution in order to do that. Another client we had, they had minerals, hydrocarbons in the ground that were um, they're trying to tie these tokens to those assets. I mean, they had legitimate assets, oil and gas assets, different kind of mineral rights, and they're attaching these tokens to these digitized digital tokens as a form of ownership, which is super brilliant. Um, but certainly, obviously, that um, is I mean, it's not problematic, but it's like, hey, you're still not. The Genius Act isn't kind of come in and say, oh yeah, you're not a security either, because number one, those in the ground assets, those mineral rights, or and whether it's oil and gas or different kind of mineral rights, they're not liquid. They're not tied to liquid assets like a dollar, like liquid securities. Um, And so therefore we still said, hey, you know what? Not the end of the world, but hey, securities laws still apply. You still have to, again, offer these under Regulation D. Again, could they joint venture with maybe a bank or a financial institution? Yeah, they certainly could, or become one themselves. But in most cases, it's a funny so many people, they try to jump through hoops and do kind of back twists and try to not be a security, but when it's like, look, in most cases, securities laws are going to apply. So, rather than try to fight it, I mean, unless you want to try to change legislation, change the legislative landscape, then, um, just go ahead and comply with the securities laws. There's plenty of exemptions that allow the issuance of any kind of digital asset under, whether it's Regulation D, Regulation crowdfunding, Regulation A, like if they're a registered offering, non-U.S. investors through Regulation S. And so, you know, um, all this time and effort, you spend trying to not be a security. Look, you could certainly, say, look, I mean, you said you could disagree and say, hey, we don't think we are, but we're gonna just go ahead and, um, from an abundance of caution, we're gonna belts and suspenders, we're gonna go ahead and provide full disclosure anyway, and have covering exemptions and all of that, right? So, anyway, yeah. So again, if you're issuing any kind of digital securities, I mean, more likely than not, I mean, there again, you could have a unique situation where that this Genius Act does apply. But anyway, but it's something that you certainly need good, seasoned legal counsel, securities counsel specifically, like myself, Mangum and Associates. I've been practicing over 25 years now, 26 years now. So, um, yeah, we're happy to take a look at your particular cryptocurrency or your digital asset type of offering, your tokenized offering, and certainly help you out. Make sure it's good to go. So, anyway, thanks for watching, and hopefully this video is helpful. Feel free to share with anyone that you know that maybe have questions on in this space. But yeah, we'll see you on the next video. Thank you.